Welcome to the First District Court of Appeal, and I'd like to extend a special welcome to our Associate Judge, Judge Salvador from the Fourth Circuit in Duval County. We're pleased to have her sitting with us this month. We have two cases on the docket. We'll take them in the order in which they're listed. Counsel for the appellant, you may proceed whenever you're ready.
Good afternoon. May it please the court. Michael Lefferman on behalf of the appellant, Isiah Johnson. Seated with me at counsel table is co-counsel, Shalani Agarwal. I'd like to reserve 5 minutes of my time for rebuttal. I have to admit up front, unlike many of my other criminal appeals, that I've really enjoyed working on this particular case. Having been the former chair of the Appellate Court Rules Committee, the current chair of the Criminal Appellate Certification Committee, the question in this case would make an amazing exam question, and the question is this: in light of the facts of this case, when, if ever, did Mr. Johnson's conviction and judgment become final? When was there ever an order rendered? And, you know, it's not just in a criminal case, it's for every appellate attorney that picks up a file, the first thing you must ask yourself is, when did the order under review become final? And having served on the Appellate Court Rules Committee and knowing that the amazing judges and lawyers that work in that capacity, the Florida Supreme Court, we've come up with a framework for answering this question. And this question is answered simply by looking to the plain language of the rule, and that's what the Second District did in the Iriarte case, and considering a very similar circumstance, and said that when you do have a judgment that's been rendered because of a plea, and then there's a timely motion to withdraw that plea that's been filed, we know that the judgment is no longer rendered, or it's told, until there is a final written signed order resolving that motion to withdraw the plea. And that's the only thing under our framework that we've adopted in Florida that can allow us to determine when that judgment becomes rendered, and that never occurred in this case.
Is there any limit on the point of entry where that argument can be raised?
There isn't, simply because our system is, we need to look to that date that the judgment was rendered for everything else that occurs in the case. It controls the notice of appeal, it controls the filing of a motion for post-conviction relief, it controls federal habeas proceedings, Rule 3.800C, I could go on and on. And I get calls every single month from potential clients saying, Mr. Ufferman, can you help me? For many of those cases, their convictions are really old, and a lot of them I can't help them because their time periods have expired. But the only way I can competently answer the question, can I help that person, is I go to my staff and I say, print the trial court docket, because the first thing I need to see is, when did this judgment become final? And anyone who would print the trial court docket in this case, they would see that although the judgment was initially rendered, when that motion to withdraw the plea was filed, that made it so that judgment was told, it was no longer rendered, and would only become rendered at the point in time that there's a written signed order resolving it. So we know in the Iriarte case, the time periods in my case are a little longer than that, and I acknowledge it, but nevertheless, in Iriarte, that gentleman entered a plea, similar to Mr. Johnson. He then filed a written, timely motion to withdraw the plea within the 30-day time period, and then apparently he orally told the judge, I'm withdrawing that motion to withdraw the plea. But there was no written order on it, and there also wasn't some type of written notice that he was withdrawing the motion to withdraw the plea.
Is there any authority that requires a trial court judge to enter a written order on a motion that has been withdrawn, whether
Yes.
oral or in writing?
Iriarte, there's no other case that I'm aware of that has dealt with this circumstance, but Iriarte deals exactly with this circumstance. So moving forward in Iriarte, the defendant in that case ultimately filed a 3.850 motion, and the trial court said, this is filed more than 2 years after your conviction would have become final from the original judgment. And the Second District said, actually, no, it's not that the 3.850 motion is untimely, it's actually premature, because the judgment in this case has never been rendered, has never become final. Judge Altenburn, who I've served with on a number of these committees, writes, I think, a wonderful concurrence explaining all this. It's not, the direct appeal time hadn't even started yet in that case. So in that case, more than 2 years had expired.
In Iriarte, and I want to be, kind of drill down, in Iriarte, what they did was they remanded it because it could not be determined from the record if the motion had ever been dealt with or disposed of. So it wasn't that they just said, okay, he should have written an order. It's we are reversing, we're sending it back for there to be a determination because we can't tell from this record. Can you address, in this record, we have something very different than what the court in Iriarte had. We had, on the record, the judge addressing with the defendant his wish to withdraw the motion, and there was a colloquy. So can you address that distinction?
Very different. Again, when we came up with appellate rules, we had to come up with the idea of what's going to trigger something becoming final. And the Appellate Court Rules Committee and the Florida Supreme Court ultimately after that determined that whatever happens orally is not sufficient. And it makes sense. There may be other ways of looking at this, but those are the rules we've adopted. So when a defendant gets sentenced orally, Your Honor, you deal with this every single week, the time for filing the notice of appeal doesn't kick in from the moment you impose that sentence orally during the sentencing hearing. The time for filing the notice of appeal only kicks in when the written signed judgment is filed with the clerk. That's what makes it rendered. So the fact that something may have happened orally, that's what happened in Iriarte as well. That he apparently orally told the judge, I'm withdrawing the motion. So, and Your Honor, I somewhat disagree with your description of their ultimate resolution. They say on page 529, if the motion to withdraw the plea has not been formally disposed of, then the court shall again dismiss the 3.850 motion as his judgment and sentence never became final and rule upon the motion to withdraw the plea. When they're referring to formally dispose of, especially when you consider then Judge Altenberg's concurrence, it's clear that what they're saying as the formal disposition is under our appellate rules. There must be a signed written order. So there's a docket entry in this case. That's not sufficient under our appellate rules. The case law is clear on that. If there was any other thing that would allow for this to be considered a rendered order, what could the state point to say when Mr. Johnson's conviction became final? When would the 2-year deadline for him to have to file a 3.85 motion have kicked in this case?
Well, how are we to treat Mr. Johnson having filed not one but 2 post-conviction motions, which were addressed by the trial court, appealed to the appellate court, affirmed? Don't those presume that the judgment and sentence are final?
No. So, and again, that's the exact same situation as Iriarte. He filed a 3.850 motion, and under the same reasoning, the state would say, oh, the fact that he's filing a 3.850 motion, he's stopped from now asserting any position that his judgment wasn't final, because to file a 3.850 motion, he must be asserting that his judgment is final. And the second district said that it makes a difference what he thinks. And this isn't, estoppel applies to positions taken by parties. This is not a position by a party. This is, from a court administration standpoint, when did his judgment become final? There's only one answer to that question. And the only way we can come up with that answer is look to these rules. It's clearly defined. Look at 9.020. It's the plain language of the rule specifically says when you file a motion to withdraw the plea and it's timely filed, the judgment is not deemed rendered until there is a written, signed order on that motion to withdraw the plea. So anything that occurred in court, orally, it's no different from a judge imposing a sentence during a sentencing hearing. Until that subsequent written, signed order is filed, the time period doesn't kick in. So you may ask, are we going to open the floodgates of litigation? I would ask, all you have to do is write an opinion that says, consistent with Iriarte, send this back for the trial court to conduct further proceedings. The trial court acknowledged in his order that there are potentially meritorious competency claims. I think he's already held a retroactive competency hearing, but to the extent that the trial court feels that further proceedings are necessary, I would leave that up to the trial court to make that decision. But that's ultimately what must be decided. But as far as the trial court said, I can't do anything regarding the competency issue, which he acknowledged there's real reason to believe Mr. Johnson was not competent at the time he entered his plea. The court said, I don't have jurisdiction, but the court basically sent it up to this court and said, appellate court, you tell me whether there's jurisdiction to consider this. But unfortunately, the trial court didn't even cite to or distinguish Iriarte in any way. Iriarte is controlling on this issue. Iriarte deals with these exact circumstances. Under Iriarte, and more importantly, under the plain language of Rule 9.020, my client's conviction has never become final. It's never been rendered because there's never been a final signed order by the trial court on the motion to withdraw the plea.
What other kinds of motions would put us in this same posture that you're advocating for? Is it just this specific kind of motion? If we only had the failure to enter an order on a competency issue, would that also trigger your argument?
I don't think the rule says that a competency issue tolls the rendition of a final order. I have my trusty rule here so I can look at the definitions under 9.020, and there are certain motions both in criminal and civil cases that toll the time. Judge Altenberg said that this is a rare case. My client may be the only other person in the entire state, in addition to Iriarte, that has this issue, because Judge Altenberg acknowledged that 99% of the time when the defendant files a motion to withdraw his plea, he wants to follow through on that motion to withdraw his plea and have the court rule on it, and the court is either going to issue an order granting it or denying it, and then under 9.020 we're going to have a final order. It's going to be the rare situation, and that was the word Judge Altenberg used, where you have a defendant who files a motion to withdraw a plea and then withdraws that motion to withdraw the plea. It's going to be an even rarer situation where the defendant, in doing so, doesn't file something in writing that would withdraw it, which could trigger the time periods. The second district said we don't really know. We went off to address that in that case. I would say that the same is true in this case. I think the safer approach still would be an order, but clearly you need one or the other. You would need something in writing. So, because again, it comes down to this, and this is true in every case. This court, as a post-conviction lawyer, anyone in the world, if they want to know when did Mr. Johnson's conviction become final, all they have to do is look at the docket. But they would look at the docket and see, and applying our appellate rules, that although the judgment was initially rendered, that rendition of the order was told once that motion to withdraw the plea was filed, and there's never been, pursuant under what's required under our rules, a written order signed by the judge resolving that motion. And because of that, no one can point to anything that would cause my client's conviction to have subsequently become final. His filing of the 3.850 motion doesn't do it. The passage of time doesn't do it.
You're into your rebuttal time, so
I see that.
let me ask one question very
Sure, of
quickly.
course.
And that is, assuming that we accept that argument, why would a nunc-pro-tunc order, a remand for a nunc-pro-tunc order, not completely solve the problem?
But yes, but now, before it's become final, the issue of competency has been raised. It should have been raised before, and I have all these issues in my brief about conflict counsel and reasons that they had a conflict and didn't properly advise my client. So yes, I think you should send it back for that, but before the judge can do it, the judge is then also going to have to resolve the pending order that calls into question my client's competency. And most important related to that, the state below conceded that the competency hearing that occurred was not a proper competency determination. So there's never been and Judge Miller found that in his order as well. So there's never been in this case, for again, without belaboring the facts, I've tried to make this a straightforward academic technical application of the rule, but I don't think there's a more sympathetic client than my client from the standpoint of being a 13-year-old when he was charged, a juvenile at the time that he's filing these pro se pleadings that allegedly make it so he's waiving his opportunity to ever make this argument in the future. And more importantly, and the most important thing, the entire time he's pursuing all these things, he's still incompetent. And Judge Miller acknowledged that that is a potentially meritorious issue. And if you look at the record, and again, I'm not asking this court to make that finding at this stage, but if you look at the record, all the evidence indicates that the finding by Dr. Taylor that he was marginally competent was not a proper finding because he didn't apply the proper standards for someone who would be a juvenile, for someone who was... My client was found to be incompetent not once but twice, sent to the state hospital, and this is about possibly restoring his competency. There was never a hearing on that, never testimony from an expert on that, never an independent evaluation by the judge, and again, most importantly, the state concedes that. They conceded below that there's never been a proper competency determination. So I agree, send it back for an order on his motion to withdraw the plea, but now, since his case has still not yet become final, the judge is going to have to deal with the pending motion relating to his competency. I'll reserve the rest of my time for rebuttal. Thank you.
Good afternoon, and may it please the court. My name is Ben Hoffman. I'm from the Attorney General's office, and I represent the state. Sounds like I have a lot to unpack, and I'll get to Iriarty and the issue of competency, but I first actually want to start my argument today by quoting just a little bit from Judge Lawson's recent concurrence in the Supreme Court's Ivey decision that just came out last month. So in case you're not aware, Ivey, just very briefly, was a case about an objection made during jury selection. And the issue is whether defense counsel could renew an objection that had previously been abandoned. I think it was a day or two prior. And in his concurrence, Justice Lawson wrote, once the objection is affirmatively abandoned, there is nothing left to renew. Additionally, it would be contrary to the orderly administration of justice to allow a party to abandon an objection in response to a trial judge's affirmative inquiry made when the judge is positioned to effectively remedy any error, and then permit resurrection of the abandoned objection one or more days later when no efficient remedy is available. Now from that, I think the only words we need to replace are objection with motion, and 1 or 2 days later with 7 years later. And that's essentially what happened in this case. And Judge Norby, I think you had asked a question about Iriarte, about what was the court, or what was the second district actually concerned with. And I think you read Iriarte correctly. So in Iriarte, even though it quotes from the rule that says signed written order, it's clear from the opinion the second district was not concerned with putting form over substance. What the second district was concerned with was the fact, and there's one sentence in the opinion, I can't quote it for you, but essentially the court said, we don't know when that motion was abandoned. So the defendant filed a motion for post-conviction relief. In that motion, he acknowledged that at some point he abandoned it, unknown from the opinion, unknown from the motion, just at some point I abandoned this. The trial judge in that case did not attach sufficient documentation to show that he addressed it, when it was addressed, how it was disposed of. So it was essentially just the defendant's word that it was abandoned. This case differs in a couple of respects, the most obvious of which is we have a transcript. We know exactly when the defendant abandoned his motion. We know exactly how he did it. We know exactly what he said, and we know exactly what the judge said to him during this very extensive colloquy in which he not only abandoned the motion, he actually testified under oath that this was an unauthorized motion to begin with. He testified his public defender had not consulted with him before filing the motion, and that he didn't even want her to file the motion. So it's not only abandoned, it's unauthorized. As to the concession issue that the state attorney had conceded that it was an inadequate competency hearing, there's a couple of things with that. So one, this court doesn't have to accept concessions from the state. I hate to say it, but I actually had a case, and I think it was actually with Mr. Ufferman, where I made a concession and the court rejected it. This case presents an interesting question in the timeline because we have to keep in mind that this competency hearing occurred in 2009. And I emphasize the year for a reason. So if the hearing that took place in 2009, actually it may have been 2009 or 2010, if that had happened today where basically the parties tell the trial judge, Judge, we got this report back from the state hospital, it says he's competent. And the judge, in this case, I think his exact word was all right. Today, I don't think there'd be any question that that would be inadequate. Back in 2009, that wasn't necessarily the case. And there's actually, in one of the states, I think it was their memorandum on jurisdiction, they actually cite to this court's decision in Hunter from 2015. And Hunter, so Hunter is actually in the record, but I can supplement. Hunter then refers to Martinez from this court's decision to Martinez from 2003. The Martinez opinion is not in the record, it's cited too, but I can follow up with supplement if need be. Martinez dealt with the same thing, where a defendant's adjudicated incompetent, goes to the state hospital, comes back, and under similar circumstances, the parties tell the judge, we got this report back, it says he's competent. And the only difference in the judge's response was, all right, and then he adds the word sir. And this court remanded only for entry of a non-protunct order, and specifically said that under those circumstances, the all right sir was an oral finding of competency. So I think part of what the court has to decide is which law are we going to apply? Are we going to apply, I guess, the modern standard where all right wouldn't be enough, or are we going to apply the law as it was in 2009 before the more recent changes where all right, depending on the circumstances, could have been enough for a finding?
But what authority do you have for us that tells us which one we have to apply?
Candidly, Judge Tatiana or Judge Salvador, I don't have any that tells you which one. So that's part of why I chose my words of you're going to have to figure it out, because I'm not entirely sure, to be quite candid with you. Getting to this issue of form over substance, of whether you need an actual signed written order, ordering and adjudging that this motion is abandoned. Judge Salvador, I know you're a trial judge. I don't think realistically you would have, say, a motion to suppress evidence, and the state and the defense appear on a hearing date for the motion, and they tell you, Judge Salvador, we've resolved this case. We don't need a hearing anymore. We are abandoning the motion, and we're ready to enter a plea to the case. I don't think you would enter a written order saying, ordered and adjudged, the motion is abandoned. You can order and adjudge it's granted. You can order and adjudge it's denied, granted in part, denied in part, any combination you can think of. I don't think you would realistically order and adjudge that it's abandoned. Ultimately, what this comes down to is on two separate occasions in 2010 and 2014 respectively, this defendant filed two motions for post-conviction relief, both of which were denied. They weren't dismissed as premature. They were denied. This court then affirmed per curiam, didn't say that these were premature. It actually handled them as if the judgment and sentence were final, which by itself makes it different than Iriarte, because in Iriarte, they actually caught that this was potentially a premature motion. This court, assuming it was premature, which I don't concede that it is, but assuming it was premature, this court essentially, under appellant's logic, would have missed it both times, treated it as final, and then years later, we're going to change the argument that, well, now it's actually never been rendered. Under estoppel, that's not allowed. I mean, that is a clear case of estoppel. And then again, just going back to the competency, I don't think you actually needed the nunc-pro-tunc hearing that the judge held. I mean, ultimately, I think it's great that he did it. It was thorough. It's better to err on the side of caution. I think what ended up happening is the state and the judge looked at this through the lens of what the law is today on competency. And clearly, all right probably would not be enough today. That's the lens they looked at it through. They weren't looking at it based on what the law at the time was. So out of an abundance of caution, the state asked to have this nunc-pro-tunc hearing in which it presented its experts, the defense presented their experts, and from that, the judge stopped short of making a nunc-pro-tunc finding, ultimately concluding he lacked jurisdiction. But I think it's pretty evident in this case that the judge, from that evidence, the judge could have made that finding. So for instance, Dr. Taylor, who was the doctor who did the evaluation at the state hospital. In his report, he used the term marginally competent, and then at the hearing, we had the benefit of his testimony where he actually took that back, or tried to take it back, and said he shouldn't have used the word marginal, and explained that he used the word marginally because the defendant wasn't putting forth full effort, is I think the way he put it. He presented himself as barely competent, but in Dr. Taylor's opinion, he was more competent than the way he actually presented himself. And then you have Ms. Hendricks, who was his original trial counsel, testified that when he came back from the state hospital, she had no problems communicating with this appellant. She had no issues communicating about the case. During the plea colloquy, she testified that if she had concerns about his competency or his understanding of what was going on, she would have stopped the proceedings right there. And she didn't because she didn't have those concerns. So I think the judge is in a position that if this were to go back, he could make my position first, he doesn't have to make the finding if you apply the 2009 law. If you apply as it is today, then he's in a position to make the finding just from reviewing the record and specifically reviewing the transcript of that nunc-pro-tunc hearing. And if he finds he was competent as of the time of the plea, which he certainly could do from this evidence, then really all he needs to do is make that finding and then enter the written order, and the grounds to withdraw his plea would no longer be valid. So under that theory...
Counsel, let me ask you a question. If we agreed with the trial court's assessment that he did not even have jurisdiction over these motions, then would we have any authority to remand even on the competency issue?
No. Well, if you determine the judge that he lacked jurisdiction, then right. So there would be no jurisdiction to address the competency issue. And actually, this court's 2017 decision in Allen speaks to that. So Allen was a case where, very much like this case, you have a defendant who pled guilty to a crime, did not file a direct appeal, just like in this case, there is no direct appeal filed. He then raised the competency issue, fundamental error issue, in his post-conviction motion, his very first post-conviction motion, and the judge denied it because it should have been raised during the direct appeal, and this court affirmed and said the issue of competency has to be raised in a direct appeal, so you can't even raise it in your very first motion for post-conviction relief. So I guess to answer your question, the short answer would be yes. The judge, since we're well past the direct appeal stage, he wouldn't have jurisdiction to deal with the competency issue.
Thank you.
So again, I would urge the court not to put form over substance. You wouldn't order in a judge that a motion to suppress is abandoned. You don't order in a judge that a motion to withdraw a plea is abandoned, and I would urge you to focus on this plea colloquy. Or not plea colloquy, the colloquy the judge has during the motion to withdraw a plea. And specifically, it's on, I can even point you to the exact pages that this happens. It's pages 2089 to 2098, where, and I think the most compelling fact in this case is during that colloquy, the judge actually tells the defendants, and I'm going to paraphrase him, but that your motion is well taken, and essentially putting on a scale of 0 to 10, 10 being very likely to grant your motion, it's an 8 or a 9. That if you want me to grant your motion, I will grant your motion and let you out of your plea and you can proceed to trial. And he says no. He wants to maintain his plea. This wasn't even an authorized motion to begin with. He's getting an education in the Department of Corrections, and he wants, which is a logical reason to want to maintain a plea. He's getting his education and he wants to maintain his plea. The judge extended him that opportunity. This all could have been cured right then and there. He didn't take it. He affirmatively said he didn't want to take it. And now here we are years later, where we're potentially now putting the state in a position, and I would argue latches might actually bar it, but in a position to now prosecute or try a 12-and-a-half-year-old case. And had he taken action back then, it certainly wouldn't be anywhere near that old. It would only have been a couple years old, maybe a few years old. And that's just not, I would argue under latches, that's not right. And for those reasons, I would ask that this court affirm.
Thank you. Counsel, I know your time is very limited. Could I ask you to address the estoppel argument?
Again,
Issues that were or could have been raised, or if not raised, are barred. How do you get around that?
Iriarte. The same would apply in Iriarte. They could have said he filed a 3.850 motion, therefore he must be assuming that his conviction is final. He's stopped from us now reaching the conclusion that we're reaching. Clearly, the second district didn't do this because he was arguing it. It appears the second district simply did what the judges are required to do in our system and say, we have to evaluate this not from a defense position or a state position. We have to evaluate this and determine, did his conviction ever become final? And I submit there's no other reading of Iriarte other than they concluded that it did not because there was nothing in writing. So with all due respect...
There was nothing in the record, oral or written, that indicated what date that motion was filed, unlike our case where there is a transcript of the date and the colloquy with the defendant about the abandonment of the motion. Isn't that
Your
a
Honor,
significant difference?
How would that work? Because the transcript was ordered later. So, because there was no direct appeal because he didn't have counsel, and we keep talking about all the things he filed, but he was ultimately incompetent for everything that he filed. But putting all that aside, how would that work? In a normal situation, but for finding that transcript, the docket would read, motion to withdraw plea filed, and maybe there'd be hearing date, and it would just say hearing worksheet, and we'd never see anything else. We would never have what would be required to have some type of finalization on his motion to withdraw the plea. So this is, with all due respect to my esteemed colleague on the other side, this is not a motion to suppress that's a final order that needs a written. There are many.
Counselor, in this case, didn't the docket have an entry with the date that read defendant wishes to withdraw his motion to withdraw plea and maintain his plea granted? Wasn't that an actual docket entry?
Our rule requires this, and this is the rules that we've adopted and agreed to live by in our state. If a motion to withdraw a plea is filed, the final order shall not be deemed rendered as to any existing party until the filing of a signed written order disposing of the motion. We don't have that. This is Iriarte. This is indistinguishable from Iriarte. If the court is inclined to disagree with it, I'd ask the court to certify the conflict with Iriarte. But Judge Altenburn does a great job explaining that this is a very unique and rare circumstance. We're not going to open the floodgates. But in this circumstance, the only way when you have this type of motion, unlike a motion to suppress, unlike a jury selection claim, the only way it can be resolved is because it's tolling rendition of an order, is if there's some written signed order disposing of it that didn't occur here. Thank you.
Thank you. Thank you, counsel. Good job. We'll take a couple of minutes to clear out, and then we'll let the lawyers for the second case approach.